It's Let's Talk Legal Time once again, made possible by Newman Van Rooyen Attorneys. And with me today, I have none other than Crystelle Steyn with me here in studio. Crystelle, thank you so much for joining me.
Thank you, Jessica.
So today we are going to be chatting once again about a very important topic. Now, Crystelle, can a person's movable property be sold for not paying their debt?
Well, yes, it can. It can be sold once we obtain a warrant of execution.
Now, what is a warrant of execution against property?
So, a warrant of execution against movable property is a legal process issued by the clerk of the court once judgment has been obtained against the debtor. Now, under the judgment, the sheriff can then attach the movable goods and remove them to a place of storage until the assets can be sold at a public auction.
Now, can the sheriff sell your property on the same day he serves you with the warrant of execution?
No, usually the sheriff will first attach your property only. That is, for instance, making a list and an inventory to show us what is available. And then they will not immediately remove it. They will only be able to remove it if the warrant of execution is endorsed for an immediate removal.
What property is not allowed to be attached by a sheriff?
So first, the sheriff must explain the contents of the document they are showing and serving on you. And they may not attach property such as your personal belongings, food, your bed, clothing, etc. And they may not remove any tools that you may rely on to earn your living.
And also, what happens in a sale of execution?
So a sale in execution is a public auction held by the sheriff of the court. This happens after they have attached and removed your items. They keep it at a safe space there at the sheriff's office. Then they arrange the auction, and then the people of the public are then allowed to register and bid on these items and buy them from the sheriff to enable the sheriff to raise the funds to settle some of the outstanding debt.
And how can you stop a sale in execution?
A sale in execution shall only be stopped as soon as the sufficient money has been raised to satisfy the warrant or the order of court and the cost of the sale of the auction. That is the sale that the sheriff arranged. And then the attorneys for the execution creditor shall be entitled to cancel the sale in execution or withdraw it at any stage before an auction has been commenced.
And Crystelle, lastly, how can a debtor avoid having their assets sold?
Well, pay your debt. If you receive a summons, try and immediately start making payments or go and make an arrangement to pay, because once judgment has been granted against your name, it's not an easy or a cheap process to get it off of your name.
Absolutely. Crystelle, thank you so much for joining me in studio, as always.
Thank you, Jessica.
And that, of course, wraps up this week's edition of Let's Talk Legal, made possible by Newman Van Rooyen Attorneys.